Welcome everyone to the Code of Professional Conduct Review. There's quite a few people on the webinar, so welcome to everyone on the webinar as well. I want to start by giving some brief background and talk through our process, what we've looked at. I have two of the other members of the task force, Jackie and Richard, who will also do part of that presentation. By the way, my name is Robert Daly. We'll work through that. What we're really trying to get from this session is lots of commentary and discussion from the floor. So we've got some slides, but we'll work through them fairly quickly so we can turn to that commentary and discussion. Do feel free to ask us questions, but I'm expecting most of the comments won't be questions. They'll be, here's what I think about this thing. So remember, it's not really a Q&A session, it's a discussion session. But if you don't understand what we meant, obviously just ask us the question and we'll handle it. I wanted to first of all also say thanks to the task force members. We've been going, I think, 9 months at this point, and I have my two colleagues, Jackie and Richard, here. We have another Richard who's UK based. We have two Davids here, so thank you to both Davids. One is here, one is not here. We have Emily and Amanda in Melbourne, they'll be hosting the Melbourne version of this session on I think it's the 12th of April, with, I think, Richard, you're going to join them as well. So we'll have a chance for people in Melbourne to have a direct discussion as well. And it's the two Davids, two Richards, Jack, and Peter as well. I think Peter's here also, who's another member of the task force. So thank you all for your contributions. We've made some good progress. So our general sense was no significant change, because there was no burning platform from people asking for change. But as we went through it, we had a few areas where we didn't reach consensus, and we've highlighted those in the pack. So people, please give your view on those areas, but also your view on the areas we reached consensus, because you may have a good argument why we haven't got that right, so please present that as well. What we did this year was we met with the disciplinary task force, who was established, I think, John, in December or November last year, to see the crossover. Now, early on in our process, and we have a slide on this, we did identify there being a crossover, but because we weren't, how to put it, we had no ambit to change the disciplinary scheme or to look at it. We parked that issue, continued with our work, and now the disciplinary scheme review formed, we're bringing that together and having joint sessions to talk about it. So John has taken the role of the first responder to our presentation. So here's a couple of slides in the pack where he'll give the disciplinary scheme task force's emerging view on things. And we'll carry on working closely together. Let me just move on to, I won't run through the background, it's there for information. Mainly that the main reason we were established wasn't really a burning platform, it was because it had been a long time since the code had been looked at, which hadn't been looked at since 2009. So it was just appropriate to look at it again. And that's what came through in the commentary we received. This is the representation of where we were with the disciplinary scheme early on in our process, which is we went through what actionable conduct was, and we then went to map it to the code. And there was some mapping, but the reality is we couldn't say that the code underpinned the disciplinary scheme or vice versa. They sort of operated a bit separately. So we reached that conclusion, but then we moved forward with our consideration of the code. John will have more on that later in his response. So we did reach consensus on 3 areas, and Jackie, you've challenged me to say task force consensus multiple times and see how I do with it. The 3 areas where we reached agreement were the purpose of the code, the definition of professional service, and the definition of professional matters. So let me go through each of those in turn. Then I'll hand over to Jackie, who will do 2 of the areas we didn't reach consensus on. Richard will do the rest of those areas, and we'll also talk about next steps. And that will conclude our part. We're going to try to go through this pretty quickly without rushing it, pretty quickly. If you have a desperate question of understanding, please give it to us. But could you hold the comments till the end, if you could, and we'll just get through this piece relatively quickly. So the purpose, this change is fairly small, but we think it's important. When we looked at the Constitution, it's very clear that codes like this are really being set up to protect the public. And the secondary aim is to really give, I guess, instruction or background to members of the Institute. We thought the purpose wasn't clear in that regard, so our view is we should reshape it to make that clear and to say that the purpose is to set up minimum standards for the protection of the public, but noting that in doing that, we're promoting the good standing and reputation of the profession. So, but the emphasis is turned around to being the public as being the main concern. That does align with the Constitution. So that's why we felt comfortable and we reached consensus on that point. It does also reflect the shift in, I think, the public view of professions over time. So I think it's important to recognize that. The second item was on professional service. This is really a modest enough change, but we felt we had to give a basis for what would be professional services. It's not quite covered in the previous one. It's a service provided by a member in a professional capacity, but that could be very broad, and we dealt with a lot of really, I'd almost say, exotic examples of people who were dancing instructors and other cases, and we could see how you could almost read that into that wording, and clearly we never mean that. So hence we went with this other approach of a service provided by a member where a principal reasonably considers to be in pursuit of the profession of actuary. We did struggle with that because how do we define it? We felt the test should be the test of a reasonable person who might want to use the services of an actuary. Of course, if that person is unreasonable in thinking someone's doing actuarial work, it wouldn't fall under that. It would have to be their reasonable view. The bit about payment of pro bono is really just trying to wordsmith the previous definition. It's no change. And then the third item was professional matters, which wasn't defined. So there was this comment on professional matters, no definition went with it. So we felt we should define it, and we went with matters involving the exercise of professional judgment as a way of defining what is a professional matter. So that was the third item. I might now pass on to Jackie, and you're going to do the first two task force consensus items. Thank you, Jack.
So the 4 areas that the task force didn't reach consensus on were around consideration of whether our advice should always be impartial or not. Secondly, the profession's stance when a client, a principal, asks if they can edit our work or change the format of our material. The third one was around, and this is probably the most discussed one, was around whether we should change the format of our code to make it simpler, more principles-based document, and I expect that'll be the one that maybe causes the most discussion around the room. So Richard will talk to that one. And then we'll the definition of prescribed actuarial advice and the different standard that currently applies in the code to that. So I'll cover the first 2 and then hand over to Richard for the next 2. So impartiality, the code currently requires us to be impartial except where partiality dictates. So for prescribed actuarial advice, we must be impartial, but there are circumstances when we may not feel that we need to be impartial. And there was quite a bit of discussion within the group around the circumstances when you might want to be impartial. So you might want to be partial. For example, when you're advising a particular party, maybe in an M&A, when you might not be impartial on either side. So, but then I guess the question came up around, could that be seen as bad for the profession? So, so we just wanted, so we didn't come to a consensus on that. So we're definitely interested in the views in the room on that one. The second one that we didn't reach consensus on was around principles changing the format of advice that we provide. And the reason for that is because there's a clause in the code that currently says a member must not provide professional services to a principal when the member reasonably believes that the result will mislead third parties. Now, of course, if we're providing advice to a client or a principal and they are then given consent to actually edit or change that material, then how do we know if that material is then going to potentially mislead third parties? So a question came up around, is there sufficient guidance in the code around whether we should be given consent to actually allow principals, clients to actually edit our material, or should we make it a requirement that they can't give consent for our material to be changed? So again, there was sort of divided views on that and the pros and cons, and we didn't reach consensus, so we're definitely interested in the views in this room. So I'll now hand over to Richard, who will go through the next 2 items.
Thanks, Jackie. So the first of my 2 is the question of whether, despite the general view on the task force that the code could continue with minor changes, maybe an alternative approach would be to replace it with something much shorter, much simpler, and principles-based. And the reason for that is in these first 3 points, that although the code is referenced in the disciplinary scheme, the details of wording in the code, that they're known to cause issues. The very fact that we're talking about minor wordsmithing to just clarify something today is evidence of that. The disciplinary scheme, contrary to popular belief, doesn't actually depend solely on the code. So the disciplinary scheme talks about actionable conduct being professional misconduct. One of the definitions of professional misconduct involves a breach of the code. Or unsatisfactory professional conduct, which is a lower level of misbehaviour. One of the definitions of unsatisfactory professional conduct involves the code. Or conduct likely to bring discredit upon the institute or the profession of actuary, which you would have thought was covered by the code. It doesn't mention the code. So while the code could perhaps underpin the disciplinary scheme, as we understand it does in the UK, it doesn't at the moment. So it's not as if changing the code is going to cause our whole disciplinary process to come crashing down. In fact, there's an opportunity to use the code as a positive document instead of a negative document. And we've taken the example of the engineer's code, which is it's on the back of the handout, if I can just find it. The actual code is a 1-page code. It's got 4 essential sections. They say just what I've listed there. Demonstrate integrity, and then there's some points. Practice competently, there's some points. Exercise leadership, again some points. Promote sustainability. And in fact, the UK also has a short code. It goes for 2 pages, and it has more sections. Integrity: members will act honestly and with the highest standards of integrity. Competence and care: members will perform their professional duties competently and with care. Impartiality: members will not allow bias, conflict of interest, or the undue influence of others to override their professional judgment. Compliance: it's a long sentence for that, but you can imagine what compliance is. And communication: members will communicate effectively and meet all applicable reporting standards. Interesting difference between the 2 approaches. I think the engineers one is a much more positive one. The UK one starts off exactly the same, integrity and competence, and then then disappears into compliance and boring stuff like that. But that's an important question if we were to move to a principles-based approach. The other remaining item where we didn't have consensus is on the question of prescribed actuarial advice. And it's not really around the definition of that, although that's a question. It's around whether it's appropriate, if we keep the scheme as it is, the code as it is, whether it's appropriate to differentiate between two levels of compliance that are required. Historically, this layer was brought in order to enable the code to be extended to cover everybody without requiring the kind of standards that would be required for very clearly actuarial, appointed actuary kind of stuff. And so it's a sort of, in this area, we really have to constrain behaviour, but in the rest, we just want people to use their judgment. The questions on the task force were around, well, are two levels appropriate, or are there more than two that should apply? And if there are more than two, where do you stop? If you exercise judgment when you're not doing prescribed actuarial advice, why can't you exercise your judgment as to what you should do when you are, given that it's probably covered by all kinds of actuarial standards anyway that define the precise things that we want to be precise about. So that's the question there. Should it continue to require different standards for prescribed actuarial advice and other professional services? So, Rob, I was expecting you to come and finish, but I'll finish if you like.
I think on consensus questions and feedback, why don't we come to those after John?
So
we might, if you could
all I was doing was to say we've got slides now that list the 3 consensus questions and the remaining feedback questions, including the one we didn't actually have a slide on, which is, well, what else should change? Question 8. Do the same with the current and next steps as Rob did with the background, and just give you time to look at what's up there. What's significant is that we met with this disciplinary scheme review committee, and John will present their view, and then we will have discussion. So there we go, John. I'll let you take that forward.
Thanks, Rob, Jackie, Richard. Good afternoon, everyone. This is an opportunistic outcome in a sense. We started our work, as I think Rob said, in about November. We've got a committee that comprises 7 people, Rob and myself. We've got Caroline Bennett and David Knox in Melbourne, Peter Martin in Canberra, Rhiannon Cummings here. I think that's the group, plus David Bell and Narelle Bell, who is giving us drafting support. We began looking at the disciplinary scheme because there'd been a couple of complaints which had led to what you might call jurisdictional issues. There were complaints that obviously being dealt with under the existing code where it wasn't clear. Some people thought there was a clear breach of standards in some sense, but yet it wasn't automatically covered under actionable conduct. And our committee was asked to, we were given a set of terms of reference by council. We were asked to look at the scope of the disciplinary scheme and so forth, and it was really on the back of some gaps, some weaknesses that were seen or some difficulties rather in the process that was taking place with under the existing code. So we explored all of that. We concluded fairly quickly that the general structure of the disciplinary scheme didn't need any change. It comprises essentially a professional conduct committee where complaints go initially. Then if they can refer it on to a disciplinary tribunal, and if the disciplinary tribunal finds against the member, then the member can appeal to the appeals tribunal. That general structure, nobody in the end wanted to question that, but not surprisingly, there are a number of questions of detail and of process around that. So that was where we came to. But then we talked quite a lot about the question of professional conduct. I don't think there's no great disagreement, at least at the level I'm talking about, over whether professional conduct, when you're giving advice, whether, you know, the references in actionable conduct to giving professional advice are not controversial. But the question is, where is the boundary? At what point do people in their general conduct or behaviour bring discredit on the institute, or otherwise cause difficulties that might, by the community at least, be seen to be worthy of some kind of at least investigation by the institute? So we debated all of this and came to the conclusion that whatever is done, there's all conduct that could be called into question by the institute or complained about should somehow come under the code. And we also didn't want to see these, what I just referred to before as a jurisdictional problem about deciding whether a complaint should or shouldn't be dealt with. So that's where we came from. And when we had this joint meeting a couple of weeks ago with Rob's task force, and that view came fairly strongly from our group. I don't think there were any dissenters, but yet that's been a debate in Rob's committee. So let me move forward. At the moment, actionable conduct is the sole trigger for investigation, and its meaning derives from the prescriptive definitions that I think Richard put up on the first slide, and also being recognised as a fit and proper person. That can be, but that's very vague. Why is this a problem? It requires codification, as we've got now. You've got a set of descriptions of things that are actionable conduct, and anything that's not in that definition is not actionable conduct, essentially. And unless you could bring a case of not a fit and proper person, then there's nothing to respond to. Codification itself is problematic. It doesn't cover all unacceptable behaviour, and there are a range of different examples of what might be unacceptable behaviour, but if you try and codify that, you're building a long document and you're telling people what they can and can't do rather than dealing with it some other way. You end up with this boundary problem that I've already referred to. There are two problems with having this jurisdictional place problem, this boundary. One is that people are debating whether or not it is actionable conduct. That itself is a great distraction. And it's more than a distraction. It's a distraction initially. It can be expensive. You might need lawyers and lots of time taken up with members of the profession or of the institute. And then you still got a problem because there might be behaviour that a lot of people think should be dealt with, but which can't be because it's decided that it's outside scope. So this is where we've got to. Now, if we continue down that path, we're actually out of step with other professional organisations. Richard's already referred to the London Institute, or the British Institute, and the Institution of Engineers. It so happens that the Chartered Accountants have also revamped their code quite recently. They did it. It began in about August last year. It was approved by their members. And those three organisations have essentially a principles-based code where every complaint of any kind is covered under the code in some sense. And So this is why I've put the heading on this slide, a flaw in the code, because our view in our committee was that that it would be much better to go down this route than to stay where we are now. Just to spend a couple of minutes talking about the benefits of a principles-based approach, and I think Richard's already introduced it, and I've already indicated a couple of things. But so the first point here is it avoids the pitfalls of attempts to define exhaustively the scope of unsatisfactory conduct. And it can accommodate and reflect diverse and changing circumstances of practice. Now this is a very important point, because if you think of standards of behaviour 10, 20, 30, 40 years ago, that they've changed progressively. It used to be the case that if you went bankrupt, you might as well go to jail because the community shunned you completely. These days, people deliberately go bankrupt sometimes. So, you know, the standards do change, and there are all sorts of other issues around that I'm sure you can all think of many examples. And so what we want is a code that is not going to be out of date next year or the year after or the year after that. And the way we do things at the moment, I think the debate over some of the things that have been put up on on these slides illustrate that you get change, and you don't want to have to change the code often if you can avoid it. The opportunity here too is that modern codes emphasise protection of the public as a principal aim. Now, that might seem pretty obvious, and we'll talk about it, but if you go back far enough, not that long, maybe 30 years, just about every code of every profession seemed to be aimed at protecting the profession, and professions would close ranks and protect their members who may have misbehaved in some way from being judged as unprofessional. Now, the modern world doesn't allow that. The years have passed where it's some years now since we've had non-actuaries, and most professions, I think all professions now have non-practitioners of their own profession on their dealing with their code or with their disciplinary scheme. So we need to be much more open, and so protection of the public is an opportunity in a way that we can emphasise more. And a principles-based approach does allow, in fact, it anticipates that personal conduct as well as professional conduct can fall foul of the principles or the standards of the profession. And it's highly desirable that that be the case. I'm associated with the Chartered Accountants scheme. They have an oversight committee for their scheme because it's new, and so I hear about some of the things that go on there, and there are something like 110,000 accountants in Australia who are chartered accountants, and I hear some of the stories about the way people deal with their clients. You know, some are really rude, some overcharge, some just avoid contact with their client. There's all sorts of bad behaviour that goes on. If you try and assess that behaviour against accounting standards, you don't get anywhere. But yet these people are doing bad things, and the profession needs to protect the public and itself against those. So that's kind of what this is all about. Now, one of the problems that people see with principles-based codes is that they give the appearance of certainty. Sorry, they do not give the appearance of certainty. It looks like they're too vague. You wonder, how can that work? Well, I've experienced this firsthand in APRA, where everything in APRA these days is principles-based, and you rely on the process. In their case, the supervisory process. In our case, it would be the disciplinary scheme, to rely on that process being a good process in order to deal with those things, because you have fewer rules, but you can give guidance. You can give some precedence, although that can be fraught with difficulty because no two cases are ever the same. Nevertheless, there are ways of responding to this lack of rules or lack of certainty that appears in a short principles-based code. And then you're relying on the informed and sound judgment of those who are involved with the disciplinary process. So that's where we ended up. We put that to Rob's committee the other day, and that's led to our committee being invited to put this forward to you today. It probably extends what Richard was saying, because I think your own remarks were pretty much in this direction. Be interested to hear hear other views. Thanks, Rob.
Thanks, John. We'll move now to sort of comments from the floor. Because while the webinar works, you need a microphone to speak into, so we can record it and the people on the web can listen. The people who are on the web, there is a lag in what you're seeing. I think you can email your questions through, and then we'll bring them, or your comments through, and we can bring them up to the front. It's not quite as easy to participate on the web, unfortunately. So let's go back to that. I might just go back to the questions to just give you some things to think about, but recall you don't have to follow these questions as you work through it. So I'll now wait for comments.
Hello, my name is Sharanjit Padam. I'm a member of the Institute, but I've also had particular experience in being a member of the committee that drafted the 2006 version of the code. I've also been a member of the Professional Conduct Committee, and in certain, what are they called now, sort of investigative committees for a few cases. And last year I had the, I was going to say privilege, but I'm not sure I would say that word anymore, being the acting convener of the Professional Conduct Committee, which has roles set out in both disciplinary scheme and in the Constitution. So my comments, by saying all of that, I'm trying to say that my comments are coming from experience of actually trying to apply these things in practice. So, of course, I'm bound by a lot of confidentiality, which I would not want to break. So what I'd like to do is present, say, maybe some series of images that would convey some of these things, my thoughts. So the first image I want to present is that of a toothless tiger. And the pathos that you might feel when you come across a toothless tiger. In the sense, and the way I talk about that is where a lot of, say, industry associations, maybe not so much professions, have volunteer codes of conduct, or codes of conduct that don't actually have any teeth behind them. They're not backed by any kind of enforcement. And I think for me that the pathos of the toothless tiger is exactly what I experience with those. And I think the public, whose perception is incredibly important when it comes to the issues of the code of conduct for a profession, also see through that and see the toothless tiger and say hello kitty and walk away. So I want to warn about sort of that kind of thing. The other one I want to warn about, which I think is even more worrisome than the toothless tiger, is the tiger with dentures that fall out every time it opens its mouth, which I think probably is the best image to describe my experience of trying to apply the code as it stands in the disciplinary scheme in practice. So having left that images, I wanted to say a couple of things that come out of that experience. I know it's very fashionable and and I think very seductive to talk about principles-based approaches. And it's definitely the way that trends go, and it just seems so obvious, like why would you do anything else? In practice, my experience has been that the principles-based things become difficult to apply and difficult to enforce, and there's always some way of finding a way around those principles. So I think that what our current, and also on the issues of principles-based thing, when the 2009 review came up with its review of the Code of Conduct, it explicitly said we want to make the code more principles-based and less. So it just seems to me all these cycles, in 2006 we thought the same thing, that everyone thinks there's something simpler here, and they set the code out and they want to go with this principle-based, but you end up having to compromise and having these hybrid kind of things. And I think from a practical point of view, and we are a practical profession when it comes down to it, we should accept that there are some things that we just have to be prescriptive about. in the interest of the public, in the interests of the profession. And I would highly caution against assuming that if it's prescribed, it must be wrong somehow, because that's terribly fashionable and I don't think actually lasts. So I will write to the committee and have lots of detailed comments, but that's what I wanted to say publicly. Thank you.
Thank you. Much appreciated. And I would make the point, we're not going to respond to many of the comments because we're trying to soak in all the commentary, and we'll work as a task force to reach a consensus. And that's why on some of these topics we deliberately didn't reach a consensus, because we wanted to hear from members first. So it does feel a bit odd when you're getting questions to the floor. I won't be responding to most of them, but thank you for the comments. And who would like to go next?
Thanks, Rob. Yes, it's waking up now. David Minty. I will state my conflict of interest here. I'm a member of the task force, as Rob mentioned earlier. I thought it was interesting, John, your comments and observations. It seems to me that rather than a disciplinary scheme going forward, then we might in fact have a complaints resolution process, which is something which is more focused on if someone, member of the general public, has a complaint, then there's a definite process that they can follow to go through. Now, that probably flies almost in the face of what Saranjit's just said, in some ways, in terms of there may even be more steps in the process after that. But it would seem to me that that may in fact be an important part of the rebranding of that element of the process. I apologise that that actually only came to me as I've been listening to the presentation now, but I think that may be a way forward.
Thanks, David. Just reminding people on the webinar, I think you can email in your questions. Is that right, Liz? Yep, so just remember there's an email you can use for that. Sorry, John.
Just to expand briefly on David's idea, that our committee is looking at a range of things, and that what you just said, David, you just gave it a label, a complaints resolution process. We are definitely looking at different penalties. At the moment, the range of penalties for misconduct is very limited. We're also looking at other things like, if people have mental health problems or some other kind of problem, we're looking at, if you like, in the rehabilitation direction as well. In other words, it's not just you contravened the code, you need a penalty, and we're going to hit you with a penalty. There's more to it than that. And so, David, we hadn't discussed the label, but we are looking at a wider set of responses, and that suggests to me too that it should all come somehow under the code if possible, rather than having some things that are outside the code and some things that are inside.
Sorry, Jenny, would you like to?
Thanks. This is a question, sorry, because I'm here to listen and learn about what people think. But I'm just interested if you have spoken to the engineers or the chartered accountants to get some feedback on particular cases that they have had and how the principles-based approach has worked.
So if I answer for the Code of Conduct Task Force, we haven't. I think it's actually quite a good idea, but we have not. We did have the advantage of having Richard Hartigan, who's a member of the UK Institute, who gave some insight on how that's worked. He's also involved in their disciplinary scheme. I'm a member of various other institutes, so I was able to get some inside knowledge, but it's a really good point. So that's something we might take on as part of our reaching consensus. The disciplinary task force has spoken to the chartered accountants about how their scheme is operating. So they've already done that consultation.
Martin Mulcair. I'll wear hat today as the facilitator of the professionalism course, where as part of that, a core part of the afternoon on day one is sharing, discussing, working through some case studies with the Code of Conduct as its focus. So the three things I like to pick up in the the ones that you're yet to come to consensus. The first is impartiality. And it's one where the discussion, especially for our younger members, the initial response is a little bit surprised that professional is allowed to be partial. But given the example, and you gave one, if you looked at it just narrowly, you'd still think, I'm concerned about the image of a profession that's allowed to be partial. But if you look more broadly at the principles and the number of other areas around maintaining objectivity and still choosing suitable assumptions and taking responsibility in professional behaviour and appropriate communication, I've got to say I'm comfortable with the idea of a professional advocate and being able to support a view. And most of the people are pretty comfortable with that in the discussion. The second was the question of principles. I'm not going to take a view on that one, other than there's no doubt that members of the profession do need guidance in interpreting the code, and at the moment there is a fair bit of guidance in there. If we went to the one-page, two-page version, then that would be fine, as long as there was still guidance for members, because otherwise where else are they going to go? So I think if we're going to go principles, and I can see, I think it was very well presented, both sides of the argument, there will still be a need for a supporting document of guidance. And the last, the concept of prescribed advice. I think that the code, whether it be short or long, has to be focusing on the majority. If we think of the proportion of members, and this is for members, not just fellows, proportion of members who are actually giving prescribed advice, it seems to me to be an unnecessary distraction. And certainly the discussion, the professionalism course, where hardly anybody there is giving prescribed advice. And that prescribed advice is already very well monitored, managed, bounded, defined in terms of professional standards and legal requirements. I don't think it needs to be dealt with explicitly in the code.
Thanks, Martin.
An observation on your on question one was about the purpose of the code, and as I recall from what you put up, it is about...
There's a way of doing that, so I'll try to do that.
It refers exclusively to professional conduct, and yet what we've been talking about is conduct that is... I mean, if you want to debate the word professional, you can, but it looks like it's narrower through having the word professional in there than if it was expressed in some other way. And this is the principal issue that our committee is trying to deal with, is how you make sure you have the whole thing as expansive as you need to be to deal with all possible circumstances.
I think it's being on this code task force, I keep on reminding myself it's the code of professional conduct, because I keep on thinking it's the code of conduct, and it is the code of professional conduct. I think that's the nub of John's point, is why is it just professional conduct? That's a good point. Waiting for other comments, I might just comment briefly on impartiality, because my sense is there's another issue behind it which is actually more important, which is the issue of conflict. Because, for example, I'd be deeply disturbed if I had a lawyer representing me who decided they were going to provide impartial advice, because I want them to provide partial advice. So there's clearly areas, but there's no conflict there. Everyone knows that lawyer is acting for me, providing me with partial advice to defend myself outside. So there's no issue with it. So actually, my own view is the issue is not impartiality. The issue is dealing with conflicts adequately. Because the problem is, if someone thinks you're being impartial, but you're being partial, everyone needs to know about that.
And that's generally the issue of conflict. That's right.
Yeah. So I think it's really the conflict is the issue, not the impartiality. Good. And with the chair breaking the first rule of commanding the floor, who else on the floor would like to comment? I think I can see Liz at the computer, so I'm hoping there's an email that's coming through. Yes, I think there is. Good. Sorry.
Just some personal thoughts in my capacity as a personal member. Sometimes principals these days omit or edit the advice or report we give them, and they only publish certain sections or emphasize certain sections more than others, which inevitably would change the overall flavour of the advice. So the question is then when does the responsibility become theirs and not ours? Because it could be construed as, the principal is there to mislead, or, that we haven't taken all the necessary action to prevent a misleading action from having taken place. So that's one thing. The other thought I had was on the principal versus prescriptive. So sometimes for example, right, a situation where someone is being a rude person, is that unprofessional conduct, or is that just conduct of a person being rude? And if it's actionable conduct, then if it's principle-based, they could say, well, it's not said anywhere that I couldn't say this word or that word, or I couldn't, do this to my client or to some other member of the profession. And so how do you get around that with a principle-based advice, because a principle-based approach? Because they can come back and say, well, it's not said, and then you get into a legal argument as to what is rude and what is not rude.
I think you're pointing to a real issue, but I don't have an easy answer to that point. It's a good point. David?
David Rush. One thing I noticed, I think it might be on the next slide actually, the International Actuarial Association has recently, a couple of years ago actually now, released what they call ISAP 1, which is not unlike our code, but it's kind of a lower standard, I suppose. But they've used the term actuarial services. And when it came for the Professional Standards Committee to look at that and consider whether it was appropriate to adopt ISAP 1 in Australia, the definition of actuarial services tied us up in knots. Can I describe it like that? Yeah. And I noticed in your definition of professional service, you've said, which a principal reasonably considers to be in pursuit of the profession of actuary. Now, I suspect that when it comes to deciding what is the profession of actuary or pursuit of the profession of actuary, you're likely to also be tied up in knots. So I just make that comment as well.
Thanks, David. I'm inclined to agree with you, but again, I'm trying not to give answers. I've got some comments from Duncan Rowlandson on the webinar, so I know Duncan will be there, so I'm going to read out his comments so people can take his view on those. And he's gone through each one for us. So, number one, he agrees. And number two, he considers this needs more thought, especially in view of any changes we make further on question 4. His view is if question 4 doesn't get up, he would be happy himself with question 2 approach. Question 3 he agreed with. We've got a question 4. On question 4.1, which is on the slide, people can see it, his view was no, and he said this was discussed at length in the last major review, and it was a considered and deliberate change born out of some real issues that members were contending with, particularly in areas of work which are not the sole preserve of the actuarial profession. So partiality is not expected or unusual in some areas of such work. 4.2 he does agree with. 5 he thinks no, but he thinks the question is misplaced. So he's going to give some more detail to the task force. I mightn't go through that now because he's got an argument which we'll work through. Question 6 he feels is a worthy ambition and shouldn't be dismissed, but he doesn't think it should be undertaken as part of the current review, particularly as there was no burning platform perhaps consider at a later time. I might actually talk on that point a little bit in a second. And question 7, just to complete Duncan's comments, he agreed, and he agrees that different and more onerous standards should apply to the prescribed actuarial advice. So I'll come back to question 6 in a second, but I do want to keep the floor open for member comments.
Hi. So on questions 1 and linked to 7, I'm a little unclear about exactly where we are with this protecting the public. Not quite sure whether we're protecting them from ourselves or acting as an institute to protect them from the wider issues in the financial markets. I'm not sure whether the code addresses either of those issues. I suppose when I read the code, I see it as providing support to the users of actuarial services, which is perhaps not the same as the general public. So on that point, moving to point 7, the users of the actuarial services for prescribed actuarial advice are different to the other users. So it'll be the regulator, the people who set the actual requirements of the appointed actuary, etc. Those people may have different levels of standards that they might expect compared to other people who are using actuarial services. So they may expect a different standard of conduct. On the impartiality one, in the UK, I remember a project where it was in participating business, and a consulting actuary was employed to be the consumer advocate, to actually advocate the position of all the participating policyholders who didn't even understand the project was going on. That was a really important piece of work. It was hugely beneficial. It changed the project in a number of ways. And that seems to be absolutely in line with the intention of the code to support those who are using actuarial advice. On the principles-based one, and I was looking through the engineers one, and I thought we could probably chuck it in as the actuarial one with a couple of words changed. It didn't seem obvious to me that this was really something that defined our profession. What we're seeking to provide as a profession to the users of actuarial services. I thought the existing code looked at a more measured document saying exactly how we're trying to protect users of actuarial services. And yes, there are limitations on that, but maybe adjusting the disciplinary process perhaps would be a better way to go about that.
Thank you. Colin, I can't remember whether you gave your name, but it's Colin Vincent.
Sorry, Colin from Munich.
Yeah, quite good. I can read your name tag, which I'm impressed with myself. But just a reminder to give your name before you make your comment, so we know who said what. Thank you, Colin.
Shiranjit, having my round 2. The other area, I think, it certainly caused me a lot of time and effort spent and long phone calls and discussions, was this question of, do we keep it as the professional conduct or do we expand it to personal conduct? Now there's interesting precedence which I think is relevant and certainly helps people to think about this issue. There has been a case that has been published and publicly notified that a member was disciplined under the scheme. They were found to have sexually abused someone, and that went through a legal process. Following that, they were, I can't remember if they were expelled or whatever it was from the institute as well. So, and I'm not sure people would argue against that or for that or whatever, but it does make it relevant that personal conduct, that had nothing to do with him being as an actuary, became relevant to how we treated that fellow member within our profession. So I'm not arguing that personal conduct has no bearing on it. But I would like to say something else, which is some of the best actuaries I've worked for or with have been the rudest people in the world. And you all laugh, and I hope that's a laugh of recognition. And I believe that actually our profession wouldn't be where it is today if it had not been for the forging self-confidence and arrogance of some of our forebears on whose shoulders we stand. So again, you know, I think there is extreme merit in saying that to confine ourselves to professional conduct, to confine ourselves to a small area where we are absolutely clear, and again, this is me arguing for prescription rather than principles, rather than seeking to bring in other things where, so for example, suppose one of our members of the profession was accused of bullying in the workplace. Should we regard that as a professional matter? Well, in some ways, yes, some ways, no. And I think it's a really good example for us to think about in terms of the application of the code. And I believe I've talked to you about, Robert, about this example as well. And I've come to a place where I've said, well, no, I don't think this is a professional issue. And one of the reasons is that is actually a practical impact. The more we include within these rules, the more people would use, I hope, the disciplinary scheme to enforce. And so we end up having to look at bullying as an issue through the disciplinary scheme, which I don't think is what we want to spend our time on or the limited resources we have. I'm not saying it's not an important issue, but what I'm saying is that there are other resources that can be applied to deal with those types of issues, and therefore we shouldn't seek to overlap. We should seek to keep to our corner and make it very clear. So that's what I'd like to say on that one. Thank you.
Thank you. David Bell. I wear two hats. One is I'm a member of the Disciplinary Scheme Review Committee. I'm also on the Medical Council of New South Wales, where I'm a member of the council. And the council is effectively the disciplinary scheme for the medical profession in New South Wales. And the medical profession in New South Wales is highly regulated and highly prescribed in terms of the rules we have to follow. And so what happens is that when we face a case, and we face many, you have to work your way through all the rules first, and then you apply your discretion. So that's why I think having principles is far superior to having endless rules, because what happens at the end of the day for both approaches is that you have to exercise your judgment. I think one of the great strengths of any scheme is the people you have there who exercise their judgment at the end of the day. So that's my reflection on looking at two different sorts of approaches. One which I'm heavily involved in, which is highly prescriptive. Another is what we're reflecting on now, which is a more discretionary based approach.
Thanks, Jane.
Jenny Lyon. So it's interesting listening to this discussion, and it seems to me that what we're really trying to achieve is actually to have a culture which recognises the kind of behaviour that we want for our professions. So whether it's actually a principles-based or something which is more defined, I think it's really useful, I think it's really important that we think about how we are going to convey this to our members, and also how it's going to be conveyed to the public, assuming that it is in some way at least available to them, and to think about how we can ensure that we have the right kind of culture, and that will come through things like the professionalism course, or maybe even requiring our members to undertake some sort of training in the code, or and I haven't really thought about that. It's just become clear to me in listening to it that whatever you write down is difficult sometimes, and that in an organisation you would try to change culture in order to get the behaviours that you want, and that we should think about that in the back of our minds whilst we make these decisions. Thanks.
Can I comment on the two of you have made comments about, I used the word rude, and you quite rightly said, well, if people are rude or arrogant, that's sometimes been a strength. I agree with that. What I should have talked about was bullying and harassment. And what I think ought to be the case is that we don't talk about bullying or harassment in the code, but if people are causing serious trouble to other people, and it appears to have and that behaviour is reflecting in some adverse way on either the profession or the public, or affecting people in a way, the disciplinary scheme ought to have enough discretion to be able to respond to that. But it would have to make a judgment in every case. You wouldn't want to prescribe that if you're rude, or if you're a bully, or if you're harassing someone, that is or isn't in the code. But what you do is you look at the total circumstances and make a judgment about that. I think that's really what we're trying to do. So it's not as difficult as you think to have principles-based, but of course it's terribly important that they're the right principles and that they are backed up by some kind of guidance, which somebody else, I think Martin, you talked about the need to have guidance. You definitely need that too. But there's a difference between guidance which gives both the people who are complained against and the people who are complaining and the people in the disciplinary process. It gives them help, but you still, but they're not rules. They're just guidance, and it is clear from, I think that every case is a bit different anyway. So every time you try and put rules, firstly you invite people to get around the rules, which is a problem, and secondly, you know that the rules will either get out of date or they won't cover everything you want. So that's, to me, that's what I've just tried to express is what I think is the case for principles-based, and hopefully it would respond to the if it's done well, it will respond, I think, to the kinds of things you're talking about, unless you want to explicitly keep out anything to do with personal behaviour.
Thanks, Sean. There's someone behind you as well.
Yeah, I just want to say I agree with that, and I remember back to the professionalism course that I did in 2008, and one of the key lessons I picked up from that was around ethics, and there was a role play around different approaches to ethics, and I think the strongest form of ethics was effectively character-based ethics. So it's not a case of you know, the letter of the law, what falls on one side or the other, but whether you've been the right sort of person. And there's an example just recently in the New Zealand market where a portfolio manager employed by a fund there has been tried for market manipulation, and I guess his defence was that he was just doing what was accepted in the market, which is one form of ethics to say if what people do in Rome is fine, but ultimately he lost the case, or at least certain parts of the case, because it was judged that he was on the wrong side of market fairness, the general principles of that he should have engaged in.
Thanks. And is it Bill Drawer? Yeah. Yeah, thank you. I can see Martin's thinking of another question. Do you want to?
Okay. How time? We've got 3 minutes to illustrate.
We've definitely got 3 minutes.
Okay,
sorry if you take more.
I won't take my 3 minutes. This question of personal conduct versus professional conduct is certainly a vexed one. And if I explain the way we position this in the course, and it's in the session on the disciplinary process, and the scenario is that Linda has been convicted of dangerous driving, and it's indictable, so by definition it is actionable conduct. And there's a discussion in groups about the treatment under the disciplinary process, and people acknowledge that it's actionable conduct, but there is a discussion about the way she drives, and is that an issue for the way she performs as an actuary. And it's normally very wide range of views on personal versus professional, and it kind of makes it real from every time we do this about the different views amongst members. And then we tell them the actual case that it's based on, and it's the one that Sharanji referred to, where we had a member expelled because they had been convicted and were in jail for the particular sexual minor crime, as I understand it. And you can see an audible gasp in the room, especially from the people who said, well, personal conduct's got nothing to do with professional conduct, who kind of think, okay, maybe there are some. But I think that's the point. If we get an important word, or maybe some, that's an issue. And maybe that it is sufficient at the moment that it is convicted of, irrespective of whether that's to do with business or other things.
Chow again. Something just came to me. The lawyers, the barristers, so they have a problem with bullying. They had a problem with bullying because they're all sole practitioners and they all work as themselves in a building. And so the service providers, they're actually not staff. They're actually sort of employed by the building. And some barristers were very rude and bullying bullying the staff there, so the cleaners and whoever. But there's nothing they could do about it because they're not in an employee-employer relationship. And the Bar Association, I think, published a series of best practice guidelines on how to resolve disputes when a dispute were to occur. So if a cleaner were to say, right, so-and-so bullied me, here's the dispute resolution process. And I think it worked. So maybe that's something worthwhile looking at.
Thank you.
Sharanjit Ranthri. I think one thing, just following on from the legal point that we've touched on, one of the problems in practice, so just to give an illustration of this, is that these rules are often written, or codes of conduct are often written to be read by the layperson. You don't have to be an expert in legal stuff to understand this. And that's important because we need to be able to convey standards of ethics to our members in that way. But when it comes to an actual disciplinary process, more often than not, lawyers will get involved. And what may be principles-based, understood amongst us, what happens in Rome and all that kind of stuff, gets churned through by professional lawyers who are incredibly good at what they do and do not read the words the same way as we want them to read because it's their job to read them in the best way for their client. And that's where in practice I find the principles fall short. Because the lawyer says, nowhere in this document does it say my client couldn't do this. Yeah. Right? So I guess what I want to say from that is that please, please, please write this document not just with the lens of how are my members going to understand it, but also how are lawyers going to read it and use it to defend their clients or defend the public interest in what's going on, because that's how it's used in actual practice. And much of the goodwill that we have in how we write it, which is an important part of it, gets lost and disappears in those moments.
Good. I think that's a good point. I think we're sort of drawing short in comments. Liz, is there anything further in the webinar? Good. I might wrap it up. Now, of course, comments don't stop here, so please do email us with any further comments or thoughts. We're weighing up whether it's worth doing a survey around this. We haven't landed it, but we're thinking about it. We're really keen to get a lot of members to participate. So if there's members who weren't there or aren't here and do want to put a point of view across, if you could encourage them to do so. I think in particular, we need to remember that this applies to all members, even student members. So if there's student members in your office who have a point to make, perhaps encourage them to make that point. You can always email it to the Institute or myself or wherever you feel comfortable sending it to. The point in doing principles, just like one closing point on that, one is it does push the onus in particular cases to the people in the disciplinary system because they need to make the judgment. When if there's rules, it's a lot easier. Now, some of the debate backs and forwards, particularly the point that David Bell made, is rules actually don't always make it easier because you end up with lots of lawyers involved in debate. But there is a different balance in what we expect out of the disciplinary scheme. And the other point, which is linked to the point Duncan made earlier, writing a good set of principles is really hard work. So that's how things land. We'll take a stopgap and decide how to take that forward because it is quite hard work. So with that, I'll close it, but please, the comments aren't shot, so please keep on making the comments. Thank you. And there is a Melbourne session, so don't forget, that's the 14th of April. Or is it the 12th of April? 12th of April. Thank you.